Hello and welcome to LiveLaw Daily. I'm your host Debojit Das. Today, July 31st, marks the martyrdom day of Shahid Uddham Singh, the revolutionary associated with the Hindustan Socialist Republican Association and remembered for assassinating Michael O'Dwyer in 1940. As the nation remembers his legacy of resistance, India's courts today were occupied with questions of constitutional rights, criminal justice, public accountability and governance. We begin today in the Delhi High Court, where former JNU scholar Umar Khalid has challenged the rejection of his third bail application in the larger conspiracy case arising out of the 2020 Northeast Delhi riots. Khalid has appealed against the trial court's order refusing him bail under the Unlawful Activities Prevention Act, arguing that he should also be granted interim bail since the Supreme Court has referred the larger question of bail in prolonged UAPA cases to a constitution bench. Hearing the appeal, a division bench of Justice Pratibha M. Singh and Justice Vikas Mahajan issued notice to the Delhi police, directing it to file its response within 2 weeks. The court also directed Khalid to file his rejoinder thereafter and ordered that the matter be heard along with a similar appeal filed by co-accused Sharjeel Imam on August 27th. Umar Khalid's counsel argued that until the Supreme Court settles the law on bail in delayed UAPA trials, his client should be released on interim bail. On the other hand, Additional Solicitor General S.V. Raju, appearing for the state, requested that Khalid's appeal be tagged with Sharjeel Imam's pending case since both arise from the same trial court order. The trial court had earlier declined bail to both Umar Khalid and Sharjeel Imam, observing that it was bound by the Supreme Court's previous orders and that the broader legal issue regarding bail under the UAPA was already awaiting consideration by a larger bench. The High Court will now examine both the appeal against the rejection of bail and Khalid's plea for interim relief later this month. Our next story comes from the Supreme Court, which has ruled that a compassionate appointment policy cannot exclude married daughters simply because they're married, holding that such a distinction violates the Constitution's guarantee of equality. A bench of Justice M.M. Sundaresh and Justice Prasanna B. Varale struck down a provision in the Bihar government's 2014 policy that made only divorced or deserted daughters eligible for compassionate appointments, while excluding other married daughters. The case arose after a woman's application for compassionate appointment following the death of her father, a government employee, was rejected because she was neither divorced nor deserted. The state argued that married daughters are generally expected to leave their parental homes after marriage. The Supreme Court firmly rejected that reasoning, observing that the law cannot presume that a daughter severs her ties with her parental family merely because she gets married. The bench also reiterated that the court has consistently held that any classification treating daughters differently from sons is unconstitutional. It added that authorities cannot deny compassionate appointment by adopting what it described as a hyper-technical approach, particularly when the applicant had been living with and supported by her parental family despite the breakdown of her marriage. Setting aside both the Patna High Court's judgment and the order rejecting the woman's application, the Supreme Court directed the Bihar government to reconsider her claim on its merits within 8 weeks. The judgment reinforces that eligibility for compassionate appointment must be assessed on actual dependency and circumstances, not outdated assumptions about a married daughter's place within her family. Our third story takes us back to one of the most closely watched cases arising out of the 2020 Northeast Delhi riots. More than 6 years later, a Delhi court has sentenced former AAP councillor Tahir Hussain to life imprisonment for the murder of Intelligence Bureau staffer Ankit Sharma. Additional Sessions Judge Praveen Singh of the Karkarduma courts also awarded life imprisonment to 4 co-convicts, Javed, Anas, Nazim and Qasim. While the Delhi police had sought the death penalty, the court declined, holding that the prosecution had not established any prior criminal history or such exceptional circumstances as to rule out the possibility of reform. It observed that participation in an unlawful assembly by itself is not enough to justify capital punishment. At the same time, the court described the crime in the strongest terms. It found that the murder was committed with extreme brutality and was motivated by religion. Referring to the manner in which Ankit Sharma's body was dragged and dumped into Chandbagh drain, the court called the incident nauseating and sickening. According to the prosecution, Sharma was abducted, repeatedly assaulted, and suffered 51 injuries, including 18 caused by sharp-edged weapons. The defense, however, argued that the evidence only established the presence of a mob and did not specifically prove the individual role played by each accused, while also contending that the case did not meet the rarest of the rare standard required for the death penalty. Tahir Hussain was ultimately convicted of murder and several other offences under the Indian Penal Code, though he was acquitted of the charge of criminal conspiracy. Our fourth story comes from the Supreme Court, which has granted interim protection to former Tamil Nadu Minister V. Senthil Balaji, a day after the Madras High Court refused him anticipatory bail in the TASMAC corruption case. TASMAC here stands for Tamil Nadu State Marketing Corporation Limited. A bench of Chief Justice Surikant and Justice Joy Malia Bagchi stayed Balaji's arrest subject to several conditions. The court directed him to cooperate with the investigation, deposit his passport, and refrain from influencing witnesses or tampering with evidence while the case remains pending. Appearing for Balaji, senior advocate Kapil Sibal argued that the FIR was registered only after the change in government in Tamil Nadu and was based on material that had already surfaced in proceedings before the Enforcement Directorate. He questioned why the allegations had suddenly resulted in a criminal case only now. During the hearing, the Chief Justice also questioned the state on why custodial interrogation was necessary when the prosecution's case appeared to rest largely on documentary evidence. Representing the state, senior advocate Guru Krishna Kumar argued that the alleged corruption took place between 2021 and 2025 and that Balaji had been able to prevent registration of the FIR while he remained a minister. Justice Bagchi, however, noted that Balaji no longer held that office. For the moment, the Supreme Court has sought the state's response and protected Balaji from arrest. At the same time, the bench clarified that this interim relief is not final and may be revisited if the state is able to demonstrate that custodial interrogation is genuinely required for the investigation. Our next story comes from the Karnataka High Court, which has stayed the conviction of former Congress MLA Vinay Kulkarni in the 2016 murder of BJP Zilla Panchayat member Yogesh Goudar, pending the hearing of his appeal. A division bench led by Justice Mohammad Nawaz not only stayed Kulkarni's conviction but also suspended his life sentence, directing that he be released on bail. The court imposed several conditions, including furnishing a bond of 5 lakh rupees with 2 sureties, not leaving India without prior permission, and appearing before the courts whenever required. Similar relief was also granted to several co-convicts who have challenged their convictions. Kulkarni was convicted by a special court earlier this year after a CBI investigation into the high-profile murder case. Before the High Court, his counsel argued that the prosecution's case had substantially weakened because many witnesses had turned hostile. It was also submitted that after the probe was transferred to the CBI and the trial shifted to the special court for MPs and MLAs, several witnesses were recalled and re-examined. The CBI, however, opposed the plea, arguing that Kulkarni could not rely on evidence recorded during the earlier trial before the Dharwar court. According to the agency, that proceeding had been compromised, with witnesses allegedly being influenced, and the subsequent CBI-led trial was the one that should carry weight. For now, the High Court has suspended both Kulkarni's conviction and sentence until his criminal appeal is finally decided, allowing him to remain out on bail while the challenge to the verdict is heard. Our next story comes from the Supreme Court, which declined to interfere with the bail granted to Abdul Malik, an accused in the 2024 Haldwani violence case, while also expressing serious reservations about the invocation of the Unlawful Activities Prevention Act. The Uttarakhand government had challenged the High Court's order granting Malik bail, arguing that he was the main conspirator behind the violence and that his absence from the scene did not diminish his role. Appearing for the state, senior advocate Gaurav Bhatia contended that the case involved a threat to public order and warranted the application of the UAPA. A bench of Chief Justice Surikant and Justice Joy Malia Bagchi was, however, unconvinced. Justice Bagchi questioned whether merely attacking and burning a police station could by itself attract UAPA provisions. He emphasized that there is a constitutional distinction between public order and national security, observing that the court had serious doubts about the addition of UAPA offences in the case. The bench also rejected the state's argument that the High Court's bail order lacked adequate reasoning. Justice Bagchi observed that a person's liberty depends on the strength of the prosecution's case, not on imperfections in a judicial order. The Chief Justice also noted that Malik had already spent nearly 2 years in custody. In one of the exchanges during the hearings, Justice Bagchi criticized the pace of the prosecution, telling the state that if the allegations were truly serious, it should have secured a conviction by now. Instead, he remarked, the prosecution had abysmally failed. Holding that prolonged incarceration could not compensate for a delayed trial, the Supreme Court refused to cancel Malik's bail. Our seventh story comes from the Delhi High Court, where a dispute over the format of a television news program has landed before the court. Bennett Coleman and Company, which owns Times Now Navbharat, has sued Network 18 and journalist Sushant Sinha, alleging that Sinha's new program, Desh Ki Pathshala, unlawfully copies the format of his earlier show, News Ki Pathshala, which he hosted before leaving the channel. Hearing this matter, Justice Anup Jairam Bhambhani issued summons in the copyright suit, granting the defendants 30 days to file their written statements. The court also issued notice on Times Now Navbharat's application seeking an interim injunction but clarified that it would decide that request only after hearing the defendants. The matter has now been listed for further hearing on August 25th. Appearing for the plaintiff here, senior advocate Hemant Singh argued that the similarities went far beyond the show's title. He told the court that the program's presentation, recurring segments, and even its catchphrases had been replicated after Sinha moved to a rival network. According to the plaintiff, these similarities amount to infringement of the show's original format. Counsel for Network 18, however, disputed that claim, arguing that the expression Pathshala is commonly used across television programming and cannot by itself be treated as proprietary. The High Court will now consider whether any interim protection should be granted after receiving the defendant's response, with the issue set to be taken up later this month. We end today's edition with the Supreme Court judgment that looks beyond a single case to address a problem seen across the country: road accidents and fatalities caused by stray cattle. A bench of Justice Sanjay Karol and Justice N. Koteshwar Singh expressed serious concern over the growing number of such incidents, observing that stray cattle have become a major threat to both human and animal life. In a striking remark, the court said cattle are not meant to be natural speed breakers placed on roads and highways. The observations came while the court was hearing the case of a woman whose husband died after being attacked by a stray bull in Punjab. Reversing the Punjab and Haryana High Court's decision, the bench held that sending the family to pursue a civil suit nearly 2 decades after the incident would leave them without an effective remedy. It awarded the family 15 lakh rupees as compensation, while clarifying that the relief was granted in the peculiar facts of this case. But looking beyond the individual dispute, the court said that the growing stray cattle problem requires a coordinated response from governments. It identified the abandonment of cattle after they cease to be economically useful as one of the principal reasons behind the problem, and stressed that owners have a continuing responsibility to ensure such animals are transferred to authorized shelters rather than being left on public roads. The court also suggested a series of measures for the centre and the states, including mandatory tagging of cattle, better implementation of existing animal welfare laws, accountability for owners who abandon animals, and the creation of a dedicated mechanism to compensate victims of cattle-related accidents. A copy of the judgment has been directed to be sent to all states and union territories for appropriate action. And that's a wrap on today's edition of LiveLaw Daily. If any of today's stories caught your attention, you'll find links to our detailed reports in the description box below. For minute-by-minute courtroom coverage, judgments, and the latest developments from across the country, keep following livelawin. Thanks for listening, and we'll be back tomorrow with another roundup of the day's biggest legal stories.